I'm happy to be taking a call on this first reading debate, the Weathertight Homes Resolution Services Financial Assistance Package Amendment Bill. I want to acknowledge the work of the Minister in this area, the Honourable Maurice Williamson. This is a huge problem that our country has been grappling with for a number of years now, and in saying that Labor will support this bill to Select Committee, we recognise that the Minister has worked hard, that this bill represents a genuine effort over a number of months to try to come up with a package that will seriously address the scale and the complexity of the problem and attempt to provide relief for homeowners who have been afflicted by the leaky homes problem. So, Sir, we support this bill to Select Committee. Look forward to really teasing out some of the questions and the issues in this bill, because there are many. And I would like to use the time that we have today, Sir, to just raise some of those questions about the structure of this package. The key thing about this bill is that it provides an indemnity to the Crown for, in the case of homes, buildings that are going to benefit from this financial assistance package. That's the first thing. The second thing is that it gives the Minister the power to provide a guarantee for commercial loans that are obtained to cover the 50% of the cost of the repairs that are left over once the Crown and the Council have both made their 25% contributions. And that's the first thing I want to query, really. What we see in the regulatory impact statement is that the Department of Building and Housing, Sir, advised quite strongly against the Crown being indemnified. They said there's no reason why the Department of Building and Housing assessors who scope the repair job, that there's no reason why they shouldn't be required to stand behind their work. And I know there are quite a few people in the industry feel the same way. Department of Building and Housing said that the Crown's liability would be very limited. There wouldn't be a huge liability, and there's no reason the Crown should be indemnified. So I'd be interested to hear from government members in this debate why the Cabinet and the Minister have gone against that advice and insisted on indemnifying the Crown. The next thing, Sir, the next question really is one that the Minister raised. It's the provision in the bill which seeks to prevent so-called double dipping. It seeks to prevent people who are benefiting from this package who may then go and sue other third parties like builders, designers and architects who themselves may then try to enjoin the Council in that legal action. And this bill specifically takes away that right, Sir, and the regulatory impact statement actually says that it expects that this is a breach of the Bill of Rights to take away the long-standing legal right of joint or concurrent tortfeasors, Sir, to seek a contribution. And I wonder, in fact, whether that's something else that the Select Committee should consider, that this provision is unjustified and unnecessary. The third question I want to raise, Sir, is something about the 25% council contribution. Much of the language that we've heard in the discussion of this by the Minister suggests that if you sign up to the package, you get the 25% contribution from the council. That's what's been conveyed. But actually, in the wording, Sir, as I understand it, the bill gives the council the right to opt in and make that contribution. The council is not required to opt in. It will simply allow the council to consider, as it does now, on a case-by-case basis, what they want to contribute. And if they choose to opt into the government scheme, then clearly the bill says 25%. But councils will not be required under this bill, sir, to pony up with that 25%. And I think that's a very significant difference, in fact, to the way that it's been presented publicly. What it will give councils the opportunity to do is consider each case on a case-by-case basis, but council will hold the whip hand when it comes to negotiations. So that is a question that it would be good to hear a response from the Minister or from his colleagues. We think that clarity is needed in situations where the repair job goes pear-shaped. Now, given that the bill indemnifies DBH assessors, then what will happen, sir, if the homeowner goes into a repair project, borrows half the money, gets half from the council and the government, and then finds halfway through the job that the assessor's got it wrong, a significant value in extra repairs is needed, or they get halfway into a job and they find some more structural work that needs to be done. What happens then? And I haven't heard anything from the Minister yet, and there's nothing in the bill or the commentary that gives any reassurance in that area. Another concern... Sure. Another concern is that the bill doesn't require the remediation work to restore homes to the performance or durability requirements of the building code. And it's quite possible, in the framework that we see in the bill, that councils will insist, for example, on targeted repairs that may be entirely unsatisfactory in terms of compliance with the building code. And that's something I think that I would like to see the Select Committee take up. It's not clear to me how this will affect multi-dwelling buildings, which are particularly in Auckland, a very big chunk of the leaky buildings problem. So it would seem to me that if an apartment complex was going to benefit from this, the body corporate would basically have to get 100% of the... Okay, well, I appreciate the Minister's explanation, but it still leaves the question of whether potentially a significant number of multi-dwelling units may not be able to be helped by this bill because they won't be able to reach the requisite 75. Now, particularly with multi-dwelling units at the bottom end of the market, sir, people there are going to have very little equity in their buildings. They may not be able to afford the 50%, and that's another question about this package. And I don't mean to be pernickety, because we do genuinely acknowledge the effort and the ambition that's gone into this, but there are a lot of people who are not going to be benefited from this. Many people will simply not be able to afford to take on the 50% loan to meet the rest of the costs. Another question, sir, is that the bill doesn't differentiate between genuine owners of leaky homes and greedy speculators who may be going around now snapping up buildings that are not weathertight, buying them at knockdown prices. They are entirely eligible under this bill for what would be a massive taxpayer subsidy to repair the buildings and then flick it on at market value, sir. And I question whether limited taxpayer resources to solve this incredibly important problem should be delivered in that kind of way to speculators who could make a killing under this bill. So I hope we'll get the chance to discuss that as well. Doubt remains, sir, about the role of the banks and all this, and I know the Minister's made reassuring words, but we saw in the Herald this morning the Bankers Association saying that the banks had not yet agreed to participate. And I would like to hear from the Minister now, and not have to wait for a Select Committee. I would like to hear from government members precisely what kind of guarantee the Minister proposes for these loans. If people find themselves in a default situation, will that contract be allowed to fall over? Will they be allowed to default? Will the bank step in? What kind of premium is the government intending to pay on behalf of the taxpayer to support commercial banks with these guarantees? So it does seem contrary to what we've heard from the government on this so far, that the
Members'
banks
time.
haven't yet signed on.
Todd.